Hello. Every second year, we award the Christian Michelsen Prize for outstanding development research. This year, the prize was awarded to Professor Maja Janmyr at the University of Oslo. Maja is an extremely talented researcher. She received her PhD here at the University of Bergen in law. She has been a visiting scholar to a number of universities already in Beirut, Cairo, Kampala, and Stockholm. She's a member of the Young Academy in Norway, and she has received also the Meltzer Young Researcher Award for outstanding academic work. She's also a very engaged person, exemplified, for instance, by being a member of the Rafto Prize Committee previously, a very active participant in media in Norway and internationally. And last but not least, member of the steering committee of the Center on Law and Social Transformation. Very good. On the 15th of March, Maja received the prize for an article that asks a very interesting question. Why is it that Lebanon, which is the country in the world with the highest number of refugees per capita, has not ratified the Refugee Convention? On the 15th of March, we just had the question. Now we are very glad to have you back to give the answer. So please, the floor is yours, Maja.
So, I think this is on now. Is it a bit close to me, maybe? Is this all right? You all hear me well? So, what does refugee protection look like in states facing large refugee influxes and who are not party to the key international instruments providing for the protection of the world's refugees? And how do these states relate to the international refugee law regime? To me, it's perplexing that many of the world's top refugee hosting countries neither have signed nor ratified the 1951 Refugee Convention and its 1967 protocol. So while the majority of the world states are parties to the convention, 55 members of the United Nations are not, and I'll show you on the slide here where they are. So the international refugee regime views these states as an exception. I'm interested in these exceptions, primarily because I believe that these are not exceptions at all. If we take a look at the top 7 refugee hosting countries in the world, we see that 4 of these could be seen as non-parties to the Refugee Convention. Turkey with 3.8 million refugees, Pakistan 1.4 million, Lebanon 1.5 million, and Bangladesh approximately 1 million, together host 1/3 of the world's total refugee population. Just these 4 states, and they're not party to the convention. So Pakistan, Lebanon, and Bangladesh, they are outright non-parties to the Refugee Convention, while Turkey has ratified the convention but maintains a geographical limitation which, for all analytical and practical purposes, I would argue, actually makes it a non-party state as well. The overwhelming majority of Turkey's refugee population are simply excluded from the scope of the Refugee Convention. So what I thought I would do today is basically situate my article on Lebanon that Ottar so nicely introduced earlier, and which received the CMI award earlier this year, in a slightly broader context. I thought I would start by talking a little bit about biased international refugee law regime and a little bit about the Middle East in general before I go to Lebanon in particular. And I will try to finish off with a sort of a research agenda. Where do we take things from here? So the 1951 Refugee Convention has ever since its inception been seen as central to scholarship on refugee and asylum issues. It is the, if you will, the Magna Carta of international refugee law, and the primary basis upon which asylum seekers make their claims to, as we saw, the majority of states. The Convention seeks to set uniform standards to guide states' response to refugees and asylum seekers, including by creating a universal definition of who can be defined as a person deserving of refugee status. I ask, how global is international refugee law really? A major concern is that both the Convention's history and its current application are problematically skewed towards countries in the global north. Firstly, as we see here, legal historical research emphasizes how the Refugee Convention, in fact, never was developed to respond to global refugee problems. Leading refugee law scholar James Hathaway, for example, he has argued that the Convention served Eurocentric needs and was a direct product of powerful states' interests dominating the drafting process. B.S. Chimney similarly speaks of what he calls a myth of difference at the time of drafting that presented non-European refugees as radically different from European refugees and therefore required solutions outside of the Convention. So at its inception, the Convention was indeed limited to protecting European refugees in the aftermath of World War II. Many of you already know all this. Repeated calls by newly decolonized states in the global south for a broad understanding of who is a refugee were largely ignored. And this meant, among other things, that the approximately 14 million persons who were displaced as a result of the partition of Pakistan from India in 1947, 14 million, they were deliberately excluded from the Refugee Convention. Despite the geographical and the temporal limits of the Convention being lifted with the 1967 protocol, many states in the global south still refused to accede to the Convention. Secondly, a major limitation in current approaches to the Refugee Convention is that the study of international refugee law contains an international and Western bias, as David Cantor recently said. So any recourse to national refugee law arguably contains a strong bias towards the practice of certain states. I'm thinking Australia, Canada, New Zealand, the US, and countries here in Western Europe. We know that these states only host a minuscule of the world's refugees. And their jurisprudence also only represents a fraction of the global practice on refugees. In contrast, the practice of states in the global south in general and the practice of non-party states more in particular rarely feeds back into the scholarship on global refugee law and tends instead to be treated in isolation, so as David Cantor says, often as an exception to the true international form of refugee law. So as a result, the literature, the core literature in international refugee law either sidesteps the question of non-party states altogether or addresses it only incompletely by way of passing. So I'm hoping with my research to sort of be a part of this shift in thinking in the international refugee law scholarship, which takes us to a more truly global direction. My geographical area of research is predominantly the Middle East. And amidst a dearth of scholarship on the international refugee regime's relation to Middle Eastern countries, two seemingly opposing approaches have actually dominated. The first argues that international human rights concepts that related to asylum and refuge actually compete with local and regional understandings. So historian Dawn Chatty, for example, she's argued that the notions of hospitality and generosity are so important in Middle Eastern cultures as to make it nearly impossible for the state to adopt international refugee law, which seems to carry with it the pettiest form of bureaucratic indifference to human needs and suffering. I would like to contend that the historical, political, and social reasons and circumstances for non-accession to the Convention are considerably more complex than this approach would suggest. So, while this first approach has been taken to mean that the social obligation of hospitality effectively, again quoting Dawn Chatty, operates in an environment where international protection simply does not exist, the second approach addresses the shift of responsibility for refugees in the Middle East from the sovereign state to the United Nations High Commissioner for Refugees. So Michael Kagan, for example, has long observed how UNHCR, functioning as a sort of surrogate state, has shouldered the heaviest burden of refugee protection and assistance. And this includes everything from refugee status determination, education, livelihood assistance, healthcare, for all non-Palestinian refugees in the region. So, while acknowledging the key role of UNHCR in providing refugee protection, I don't feel that this second approach pays enough regard to the complex role of the state as well to the international humanitarian system of refugee protection, nor does it acknowledge the vital role of local initiatives in securing protection for refugees both inside and outside of the international refugee regime. So I'm hoping to overcome both of these limitations by combining a more top-down and a bottom-up approach to provide what I feel, the multi-dimensional study which is needed to sufficiently understand refugee protection in these non-party states. So with the article that we're talking about here today, this is just one step of a bigger project leading to that end. So, one way in which I've sought to remedy the deficiency in explanation for why key refugee hosting states remain non-parties to the Convention is through my recent research in Lebanon. So I've recently lived in Beirut for a year and a half, where I've focused on the Lebanese and the humanitarian response to the Syrian refugee influx that started in March 2011. And from an international law perspective, we see that Lebanon is indeed a fascinating case. It's frequently hailed by the international community for its generosity towards refugees. It currently hosts, as Ottar said, the highest number of refugees in the world by population size. And while Lebanon engaged quite actively, actually, in the drafting of the international refugee regime, it participated in the establishment of the Convention and the UNHCR. It has long insisted that it is not a country of asylum and has outrightly rejected the Refugee Convention. So in the article we're talking about here today, I make 4 arguments as to why Lebanon continues to reject the Refugee Convention. Firstly, I argue that there is a widespread and real, or perhaps simply politically expedient, uncertainty as to the obligations that come with the Convention. And this includes a belief that the Convention requires that Lebanon allow for the permanent settlement of refugees on its territory, including Palestinian refugees, who amount somewhere between 300,000 and 500,000. Is that correct, Ottar? There are different estimations here, but somewhere around that ballpark. And there's unanimous political agreement on the rejection of naturalization of refugees in Lebanon. And the government's ambition to reduce the Palestinian presence is arguably even reflected in the country's constitution. And that's quite interesting, as it was amended after the civil war in 1990. So the preamble of the Lebanese constitution refers to the quite peculiar notion of tawteen. Has anybody heard of this before, except the Lebanon researchers? No. So the peculiar notion of tawteen is in the preamble of the Lebanese constitution as it was amended in 1990. Stating that there shall be no tawteen in Lebanon. There's no clear definition of this term, but it can roughly be translated into settlement. But it's a bit unclear who shall not be settled in Lebanon. Foreigners in general, or no settlement anymore. Tawteen appears to be a sort of Lebanese political jargon primarily employed in relation to the country's Palestinian refugees. And now more recently, we also see it increasingly being used with respect to the country's 1.5 million Syrians. And for this reason, some have even argued that the constitution institutionalizes the country's strong fear of the permanent settlement of Palestinians. And this institutionalized rejection of the Palestinian presence appears to have translated into a belief that ratifying the convention brings about the permanency of not only the country's refugees in general, but also the country's Palestinian population. Of course, any look at the Refugee Convention will reveal that this is a misreading of the convention, not the least as Palestinian refugees under the mandate of UNRWA, a separate UN agency, are typically excluded from the convention's protection. Another very much related example of a misconception about the obligations laid down in the convention is the Lebanese conviction that as long as Lebanon does not ratify the convention, it is not a country of asylum. As I mentioned, there is strong opposition in the country to being a country of asylum, as this is widely believed to entail the permanent settlement of refugees. And we see in the Lebanese context, asylum is often understood as a final destination for refugees to be locally integrated or resettled. But again, the convention does not oblige state parties to unreservedly and permanently host refugees. There's nothing in it on that. Secondly, my second argument of why Lebanon is reluctant to ratify the convention brings me back to the argument of Michael Kagan and the issue of third-party responsibility for the country's refugees. And Michael Kagan has long written about the responsibility shift from the sovereign state to the UN, which is so prevalent in the Middle East for both Palestinian and non-Palestinian refugees. And in this line of thought then, when the UN becomes, in a sense, a surrogate state, to use the words of Michael, many governments in the region are likely to tolerate the presence of refugees if responsibility for them is simply assigned to a third party. So the obvious advantages for Lebanon of having UNHCR and UNRWA in place has made the state less inclined to become a party to the convention and take on many tasks of its own. The Lebanese argument goes that should Lebanon ratify the convention, it would need to bear more of the burden, practically and economically, but also politically, which brings me to my next argument. Namely that the notion of good neighborliness between Arab countries holds that Lebanon should not employ the term refugee because doing so would bind the state into positions that could violate the good neighbor principle. Because what are you really doing when you're saying that someone is a refugee and they're coming from the neighboring country? you're directly accusing somebody of persecuting those refugees. So the good neighborliness argument takes as central the general principle that states should not interfere in the sensitive issues of neighboring countries. And one way of ameliorating these political sensitivities is thus to avoid responsibility for the refugees on the one hand, and as I just explained, simply handing over responsibility for them to third parties, but also by not signing the convention, because signing the convention would, in this line of thought, entail a duty to recognize certain forced migrants as refugees. So one example of how this actually plays out in Lebanon then is the government's enforcement of the use of the term displaced persons as a legitimate terminology rather than refugees. So in Lebanon, we really don't talk about refugees, we talk about displaced persons. The Lebanon Crisis Response Plan, which is a joint Lebanese government, UN government collaboration, introduces then a myriad of terms, including the quite curious notion of de facto refugees, as you can see there, to refer to persons who have fled from Syria after 2011. And in other research articles, I've interrogated precisely what these different categories mean. Finally, then, I argue that many Lebanese government officials and policymakers consider Lebanon's accession to the convention redundant. And there are three key reasons for this perceived redundancy. Firstly, Lebanon argues that it applies the provisions of the convention on a voluntary basis. Therefore, there's no need for ratification because it does everything the convention asks it to. And this claim of voluntarily applying the convention's provisions has even been cemented in official documents, such as in the LCRP. So the LCRPs notably include a preambular text box on the first page of the LCRP, noting that Lebanon implements some provisions of the convention on a voluntary basis. Secondly, Lebanon, some argue, already has human rights obligations towards refugees on its territory by virtue of its membership of the United Nations and its ratification of a number of core international human rights instruments. So for this reason, any ratification of the convention is considered superfluous. And I would argue that this is quite a legit argument in some points, because we have a number of human rights instruments that explicitly cover the human rights of people on the move as well. But this is also exacerbated by the strong national myth of Lebanon sort of being the cradle of human rights. It's not uncommon to hear the argument, as one government official told me in an interview, in the Middle East, we are pioneers. And I've put this experience of a senior UNHCR official as well on the slide here. And I think it quite aptly illustrates this stance. But indeed, Lebanon was also a member of the 8-person drafting committee of the Universal Declaration of Human Rights. And we see here Lebanon's representative, Shal Malik, here on the slide. In addition, many Lebanese decision makers consider the Refugee Convention redundant due to the recent global developments in which many states appear to reject the convention altogether. I'm sure most of us here in this room have heard calls in these past few years for either scrapping or reforming the Refugee Convention. So these calls, as well as European countries' increasingly deterring policies, do certainly not go unnoticed in Lebanon. Lebanese policymakers are quick to point out that signatory states do not necessarily offer better practice than non-signatory states. And this is quite an enticing argument. I'm thinking maybe Malcolm and I can discuss this further on how we can measure if signatory states actually offer better practice than non-signatory states. So that would be clearly one path of further research that would suit LawTransform, I think, very nicely. But in any case, those were the main arguments that I presented in the research article that brings us here today. For anyone who's interested, it's available in the International Journal of Refugee Law in its 2017 edition. But I would just like to finish off with my ambition for the next few years. It's basically to sort of initiate a research stream focused on the role of non-party states in international refugee law. So as I mentioned, I hope to contribute to building a truly global perspective on international refugee law, one that eschews what my colleague David Cantor has called the conventional approach of giving undue weight to the domestic practice of Western states in constructing our understanding of refugee law. So more precisely, I would like to develop a framework of analysis that's actually capable of grasping the quite multifaceted characteristics of refugee protection in these states. And I'm thinking the best way of doing this is to study the practice of and the interaction between actors, not only on a global and natural level, but also on the very local level. So involving social movements and legal aid organizations, domestic courts as well. So I'm hoping that such an approach would also help us adopt a broader perspective that historically and politically situates these non-party states within the international refugee regime, but also a more focused perspective that grounds refugee protection more in the lived experiences and local initiatives. So just as a start, I've identified 5 different ways that non-party states are deeply embedded within the international system of refugee protection. So my argument is that they're not exceptions at all, right? They are a part of the international refugee law system. Firstly, several non-party states engaged actively in the drafting processes around the UNHCR statute and the Refugee Convention. I just spoke about my research in Lebanon in this regard, but it's also noteworthy that other non-party states were very active. I'm thinking here of countries like Turkey, Pakistan, India, just to name a few. Secondly, UNHCR's executive committee, the EXCOM, consists of many non-party states. Turkey, for example, has been a member since the committee's inception in 1958. Lebanon joined in 1963. And what does this EXCOM do? Well, it's tasked to advise the High Commissioner in the exercise of his functions under the UNHCR statute and to approve the High Commissioner's assistance programs. And this means that non-party states are not only responsible for repeated calls on those states who are not yet party to the convention to actually accede to the Refugee Convention, but also that they actively contribute to developing the substance of international refugee law by providing annual conclusions on international protection that interpret the Refugee Convention. Thirdly, UNHCR has a significant physical presence in many non-party states, and it also has an explicit mandate to supervise refugees in these states. In Turkey, Lebanon, and Pakistan, UNHCR has been present since 1960, 1963, and 1979, respectively. And UNHCR is also often present in these countries on the basis of so-called cooperation agreements. And what's interesting with these agreements is that the substantive content of the cooperation agreements may bind the host state into observing a fundamental body of refugee law, which is well beyond what one could expect from customary international law, which is then binding on all states. So UNHCR's agreement with Pakistan, for example, applies a definition of a refugee that is much, much broader than the definition of refugee found in the Refugee Convention. This is interesting, I think. And fourthly, non-party states still reason and converse within the paradigm of international refugee law. So Bangladesh, Lebanon, Pakistan, they've all justified their non-ratification of the Refugee Convention by claiming that even though they're not parties to the convention, they still abide by the convention's provisions. As recently as in May 2018, Bangladesh explained during the UPR review that it is not a signatory to the 1951 convention, yet Bangladesh has long been hosting refugees and forcibly displaced Rohingyas from Myanmar with full respect to the international protection regime. Another example is how international refugee law influences these states' decisions of who is considered to be a refugee or not. My research shows how Lebanon avoids using the refugee label simply because of a belief that doing so would trigger the international refugee regime, right? And trigger specific duties towards refugees. And to me, such ideas only make sense if we put them in a discursive framework devised from the definition of a refugee as it is embedded in the Refugee Convention. And finally then, local legal aid organizations engage with international refugee law in various ways. So notwithstanding the shrinking space for civil society and defenders of the rights of refugees that we're currently seeing, strategies of protection through local lawyers and domestic courts have achieved notable successes. So in Lebanon, I've studied how court judgments have removed the irregular entry charges for a number of Syrians by recourse to the right to seek asylum as embedded in Article 14 of the UDHR. Another example is from Bangladesh, where the Refugee Convention was directly referenced by the Supreme Court in cases relating to unlawful expulsion against Rohingya refugees. So simply my hypothesis here is that rather than being an exception, the international refugee regime has played and continues to play an important, albeit often unrecognized role in these states, but also that the circumstances of non-party states actually also has impacted developments in international refugee law. And I think I'll stop here, but all of this is very tentative, so any ideas you may have is much welcome. Thank you so much.
Thanks a lot, Maja, for that excellent presentation. I learned a lot. I had to ask Irina whether it was supposed to have a discussion here, because this was part of the lunch. I thought maybe this was just only for your consumption. But Mirsi said no, this is the exchanges.